Okay, so we're going to go over a few of the top 2024 verdicts. I just picked these. These are the ones, like the trials that I covered or that I followed. And we're going to start out with the clown of them all.
Court of the 20th Judicial Circuit in Fort Lee County, Florida. Criminal action. State of Florida versus Wade Wilson. Case number 19 CF 0568. Verdict. We, the jury, finds as follow as to the defendant in this case. Count 1, first-degree murder, Christine Melton. The defendant is guilty of first-degree murder. Count 2, grand theft motor vehicle. The defendant is guilty of grand theft motor vehicle. Count 3, battery. The defendant is guilty of battery. Count 4, first-degree murder, Diane Ruiz. The defendant is guilty of first-degree murder. Count 5, burglary of dwelling. The defendant is guilty of burglary of a dwelling. Count 6, first-degree petty theft. The defendant is guilty of first-degree petty theft. Dated 6/12/24, so say we all, 4-person.
All right, does either party wish to have the jury polled?
Yes, please.
All right. Just by number.
Now I will get into his, when he got the death sentence. Okay.
The nature and quality of each aggravator and mitigator. Having reviewed all of the aggravating factors proven beyond a reasonable doubt and all of the mitigating circumstances reasonably established by the evidence, the court finds that the aggravating factors greatly outweigh mitigating circumstances. Given the facts of the case, nothing in defendant's background or mental state would suggest that a death sentence is inappropriate. This court's review of other reported capital cases has led the court to conclude that the death penalty is not disproportionate in this case. Under the totality of the circumstances and evidence, the court finds no basis to override the jury's verdict. The totality of the circumstances warrants that the defendant, Wade Stephen Wilson, be sentenced to death for each count of first-degree murder. Accordingly, it is ordered and adjudged that the defendant, Wade Stephen Wilson, be sentenced as follows. Count 1, first-degree murder of Christine Melton. The defendant is hereby sentenced to death. Count 2, grand theft of a motor vehicle. The defendant is sentenced to 5 years imprisonment in the Florida Department of Corrections. Count 3, battery. The defendant is hereby sentenced to 364 days in the Lee County Jail. Count 4, first-degree murder of Diane Ruiz. The defendant is hereby sentenced to death. Count 5, the burglary of a dwelling. The defendant is hereby sentenced to 15 years imprisonment in the Florida Department of Corrections. Count 6, petty theft. The defendant is hereby sentenced to 364 days in Lee County Jail. The defendant is given credit for all time served on this case on all counts. All counts are to run concurrent with each other, meaning at the same time. All statutorily mandated fines, fees, and costs as announced on the record are imposed, and the defendant is committed to the custody of the Department of Corrections for execution of this sentence as provided by law. The defendant is hereby notified that these convictions and sentences are subject to automatic review by the Florida Supreme Court. If he cannot afford an attorney to represent him in any appeal, the court will appoint one for him. Are there any other matters to present to the court?
Briefly, Judge, the state would be seeking $17,500 cost of prosecution.
I'm sorry, how much?
$17,500, Judge.
All right. Any objection?
No, sir.
All right.
And we'd like to collect that before you get fried in the chair, please.
All right.
Cash or credit.
That will be imposed then. Any other terms or conditions?
Absolutely, Judge. We just want to make sure that Mr. Wilson has absolutely no contact with the victim's family in this particular.
There'll be no contact ordered with any of the victim's family members and anything else.
All right, thank you.
All right.
Judge.
All right, no reaction. No reaction. Light
this case: second-degree murder, falsifying physical evidence, witness tampering, abuse of a corpse, and second-degree assault. But the prior convictions are important, and they're important as well as each of them reflects not just your extensive criminal conduct, but each of them represents an opportunity after sentencing for you to have changed the trajectory of your life, to change how you were treating other people. But you were either unwilling or unable to do so. And as a result, at this point, the court has the responsibility to impose a sentence that not only punishes you harshly for the crimes that you have committed, but considers deterrence, that is, how to keep you from hurting others. In light of the egregious nature of the crimes of which you have been convicted in this case, and taking into consideration your extremely violent criminal history, the court finds the only way to do this is to keep you off the streets. To the extent you seek to rehabilitate yourself, that will have to happen behind the prison walls. Harmony was an innocent 5-year-old girl. You treated her in the worst of possible ways, in both her life and in her death. Therefore, the court sentences you as follows. On charge ID 2027112C, the charge of second-degree murder, you are sentenced to the New Hampshire State Prison for not more than life nor less than 45 years. That sentence is stand committed. That sentence is consecutive. All of these sentences, I should say now, are consecutive to each other, as well as consecutive to docket 216-2022 CR 577, which are the sentences that you're currently serving. Additionally, you're to participate meaningfully and complete any counseling, treatment, or education programs as directed by the correctional authority or probation, parole. Law enforcement agencies may return evidence to its rightful owner. You are ordered to be of good conduct and comply with all the terms of this sentence. This is also consecutive to the second-degree assault charge in the docket ending in 20. That is charge ID 1937947C. Do you have any questions about that sentence?
Nope.
On charge ID 2027113C, falsifying physical evidence, on this charge, you are sentenced to New Hampshire State Prison for not more than 7 years nor 3.5 years. This sentence is stand committed, consecutive to all of the other charges that I'm about to read you, as well as consecutive to the second-degree assault charge in the docket ending in 20 and the sentences that you are presently serving. You do have the obligation, as with the other sentences, to meaningfully participate in programming as directed by the correctional authority or probation, parole. You're ordered to be of good conduct and comply with all the terms of that sentence. On the charge of tampering with witnesses and informants, you are sentenced to the New Hampshire State Prison for not more than 7 years nor less than 3.5 years. Again, this sentence is consecutive to the additional sentences that I've read to you that I'm reading to you in this case, as well as docket ending in 20 and the sentences that you are presently serving. You have the same obligations for participation in programming, and law enforcement may return evidence to its rightful owner. On the abuse of corpse charge, on this charge, you are sentenced to the maximum penalty of 12 months at the House of Correction. All of this sentence is suspended for 25 years. If it were to be imposed, it would be consecutive to the sentences that I read to you. And on this charge, you will also have the provision of a no contact order, and that is no contact with the Sorey family, the Miller family, and the Rafferty family. That sentence is also consecutive were it to be imposed to all of the other sentences in this case and the sentence you're currently serving. On the second-degree assault charge, charge ID 1937947C, you are sentenced to New Hampshire State Prison for not more than 8 years nor less than 4 years. This sentence is consecutive to the sentences in docket 216-2022 CR 2372. This is charge ID 1937947C. On this charge, you have the additional requirement, as you have in the other cases, to meaningfully participate in programming. Law enforcement agencies may return evidence to its rightful owner, and you're obligated
This fucking guy back here about to shit his pants. He's turning so fucking red.
to be of good behavior and comply with all the terms of the sentence. Do you have any question about those sentences?
No, I do not.
All right, before you go, counsel, approach, please.
All rise.
I can't find the clip where it's a full clip of but this is her reaction after. The internet sucks sometimes. That's her brother. And then you will see right coming right where she at. Oh, she's down here. What's his name? The brother walks by. Oh, he just talked shit to her. In the blue. Look at her. She's fucking mad. Those are her parents. So this case is going back in January.
That they're innocent. I don't know who would be more.
We're back on the record.
Guilty, but let's listen.
Versus Ashley Benefield, 2020 CF 3014. I've been informed there's a verdict. Prior to bringing the jury out, I did want to make this announcement. The jury has reached a verdict, and I'm about to bring them out so the verdict can be reviewed and published. I know many of you here in the audience have been here throughout the trial, and I want to thank you for conducting yourselves appropriately throughout the trial. I realize that the reading of the verdict can be very stressful, and it is likely that some of you will agree with the jury's verdict, and some of you will not. As sometimes happens, it may be that no one is pleased with the jury's verdict. Whatever your personal feelings are about this jury's verdict, I ask you to remember that these jurors were randomly selected from our community. They were thoroughly questioned by the court and lawyers for both sides, and they were selected from the larger group to hear this case because of their demonstrated ability to be fair and impartial. I've paid close attention to this jury, and they have been attentive, observant, and focused throughout the trial. No matter how much you agree or disagree with the verdict, there are to be no outbursts of emotion. Our judicial system, in fact, our entire society, has relied on jurors to help resolve disputes for over 200 years. Their verdict needs to be respected, even if you don't understand it or don't agree with it. You ready to bring in the jury?
Yes, sir.
All right, bring them in.
She's also been out on bond this entire time, so it's not like she came from the jail.
All right, you all can have a seat. Members of the jury, I understand you have a verdict, and we have a foreperson.
Yes, we do.
Ma'am, has the jury reached a verdict?
Yes, we have.
Is the verdict unanimous?
Yes, it is.
Would you please hand the verdict form to the deputy? I need to check it and make sure it's in proper form. Thank you. All right, the verdict appears to be in proper form. Madam Clerk, would you please publish the verdict?
In the Circuit Court of the 12th Judicial Circuit in and for Manatee County, Florida, the State of Florida versus Ashley Benefield, case number 2020 CF 3014. Verdict. We, the jury, finds as follows as to the defendant in this case. The defendant is guilty of manslaughter, a lesser included offense. Did Ashley Benefield actually carry a firearm? Yes. Did Ashley Benefield discharge a firearm? Yes. Did Ashley Benefield, as a result of discharging a firearm, cause death to Douglas Benefield? Yes. So say we all this 30th day of July, 2024, at Bradenton, Manatee County, Florida. Cheryl Forkerson.
Would either side like the jury polled? State?
No.
Defense?
Yes, sir.
Members of the jury, you're now going to be polled. The clerk is going to ask each of you individually if this is your verdict and the verdict of the jury as a whole. Madam Clerk?
Juror number 15, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 20, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror 21, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 29, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 33, is this your verdict as well as the verdict of the jury as a whole?
Yes.
And juror number 35, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Thank you. Members of the jury, I want to thank you for your time and consideration in this case. I know that many of you have missed important work obligations and family obligations and other engagements that you had planned, as well as time with your families. But I want to thank you for being willing to give us your time.
This defense attorney is the one that reminds you of James Owens, the defense attorney who's representing Sarah Boone right now. Which, if you're following that case, we have day two of testimony tomorrow. Starts back.
Time and your attention and being observant to this entire trial and serving as jurors and doing your civic duty. I have paperwork that we're going to give you that will reflect your service as a juror, as well as a piece of paper from the clerk's office.
And then that's Doug's daughter.
Documenting that each of you has been here for these number of days if you need it for work purposes. If you need some sort of other paperwork for work or anything like that, contact my judicial assistant and we'll be able to get that for you. I also want to advise you of some very special privileges that all jurors enjoy. No juror can ever be required to talk about the discussions that occurred in the jury room except by court.
All right, that's enough of that. I do want to show the end where her attorney is like trying to keep her out of jail until her sentencing. Where is it?
That is substantial. As the court knows, trial headed to bail, and they under young.
A hearing, sentencing hearing, you could let her know how much time you need. Right now, the pre-sentence investigations are running a month to 6 weeks, so it'll certainly, the time for sentencing will be outside of that, but then you can let me know how much time you'll need.
Let me direct myself, Your Honor, to post-trial release if I can.
Yes, sir.
Under Youngston, I know that Younghans, rather, I know that the court is familiar with the standard. They stated in no uncertain terms, but if taken in good faith on grounds not frivolous but fairly debatable in view of the decisions of the Supreme Court, then the petitioner should be admitted to bail. And they set out for the trial court 3 factors. The first, with respect to the appeal not being frivolous, I think by the court's own acknowledgement at 2 different points in the trial, the court noted that we were dealing with novel issues that the court had not seen before. I think we certainly have good and sufficient grounds to appeal in good faith. The factors, according to Younghens, Your Honor, is the habits of the individual as respect for the law. Ms. Benefield has no prior history of criminal activity, as the court knows. Her local attachments to the community by way of family ties, business, or investments. She lives here in Bradenton, has lived here for a while. Her mother resides here. Her child resides here. The severity of the punishment imposed for the offense, that is substantial. There's no denying it. And any other circumstance relevant to the question of whether the person would be tempted to remove herself from the jurisdiction of the court. Ms. Benefield, on every single occasion over the course of the life of this case, has appeared when requested. She has never once failed to meet any obligation pursuant to the bond that she's on. As a result, we ask that the court entertain setting a post-trial bond. The only other thing that the court noted in the Younghens decision was that it's axiomatic that the exercise of judicial discretion should never be arbitrary, capricious, or unreasonable, and where the discretion is exercised in favor of denying to a person a basic and fundamental right, the reasons for doing so should be sound and they should be clearly stated. So pursuant to Rule 3.691, post-trial release, Your Honor, we ask that the court admit Ms. Benefield to bond, continue her on the same bond, in fact. And if the court is not inclined to do so, we ask that Your Honor stay the decision so that we can appeal directly to the second district. As the court knows, it's an accelerated docket because of the nature of the motion, that is to say, the bond.
Thank you. State, did you want to be heard?
Judge, I object to any bond at this point. The potential sentence is 30 years. While this defendant may have appeared at every court hearing, she was not convicted of the charge at the time. She has much more at stake at this point, being convicted of this crime, and I would ask you to deny the bond.
Any rebuttal?
No, sir.
Ms. Benefield, the jury, having found you guilty of manslaughter with a firearm, are going to remand you to the custody of the Manatee County Sheriff. We're going to revoke your bonds where you'll be held pending sentencing.
She wouldn't even stand. I was like, when are they going to handcuff her? Same shit with Laurie Shaver. I wonder what she said to her attorney. Probably like, you better fucking appeal this shit right now. And then she has to walk past her stepdaughter, well, Doug's real daughter. All right, now we're gonna watch Laurie Shaver, which is another Florida woman who unalived her husband. But this one, she buried him and then made a fire pit over him.
Has the jury reached a verdict?
Yes.
Is it unanimous?
Yes.
Please hand the verdict forms to Madam Bailiff. Thank you. All right, after having reviewed both verdict forms, the court finds that there are no errors or omissions in the filling out of the verdict forms. Madam Clerk, please publish the verdict.
Circuit Court of the 5th Judicial Circuit of the State of Florida in and for Lake County. The State of Florida versus Laurie Shaver. Case number 2020 CF 2361. Verdict as to count 1. We, the jury, find as follows as to count 1 of the charge. The defendant is guilty of second-degree murder. Was the defendant in actual possession of a firearm? Yes. Did the defendant discharge a firearm? Yes. Did the discharge cause great bodily harm? Yes. So say we all, dated this 13th day of September 2024, Mercy Langley, foreperson. Verdict as to count 2. We, the jury, find as follows as to count 2 of the charge. The defendant is not guilty. So say we all, dated this 13th day of September 2024, Mercy Langley, foreperson.
Does counsel for either the state or the defendant wish to have the jury polled?
Defense does, Judge.
All right, Madam Clerk, please poll each juror.
Angela Echevarria, is this your true verdict? Yes. Michael Keshima, is this your true verdict?
Yes.
Mercy Langley, is this your true verdict?
Yes.
Michael Smithson, is this your true verdict?
Yes.
Keith Berger, is this your true verdict?
Yes.
Tara Smith, is this your true verdict?
Yes.
Thank you. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from your attorneys, or elsewhere. From the attorneys or elsewhere, it will be up to you to decide whether to preserve your privacy as a juror. Thank you so much for your time and attention and patience this week. Our system of justice would not work without good people such as yourself.
My schedule's pretty jam-packed these days. I've got 2, free birthday parties.
You are excused from further jury service. Thank you and have a nice night. All right, Mr. Wiggs, please present your client for sentencing.
Yes, sir. Judge, at this time, we move, obviously, for attendance motion for supersedious bond. Renew our motion for judgment of acquittal, notwithstanding the verdict, all previous grounds stated and asserted.
So she was also out on bond during this, so just like Ashley Benefield.
The motion for supersedious bond is denied, and the motion for judgment of acquittal is respectfully denied. Okay.
Yes.
Is your client, is Ms. Shaver entitled to a PSI? Okay. All right, Ms. Shaver, please stand. Based on the verdict of the jury finding you guilty of the offense of murder in the second degree with a firearm, as charged in the information filed against you in criminal case number 20 CF 2361, this court does hereby adjudicate you guilty of that offense and remand you to the custody of the sheriff pending receipt by the court of a pre-sentence investigation report by the Florida Parole and Probation Commission. You will be remanded now to the Lake County Jail. Let's set a sentencing date, Madam Clerk. What's 60 days out?
Let me get with Margie real fast.
Okay.
So she can.
I don't know if I think she left.
Her roots are really going to be popping in 60 days.
Will be ordered. Is there a November date?
We can do, our November sentencing date is November 27th.
All right, November 25th, at what time? 9?
Private attorney, yes, sir.
9 o'clock. November 25th at 9 a.m. will be sentencing, tentatively, pending the receipt of the PSI. Is there anything further from the defense?
Yes, sir.
Anything further from the state?
Yes, sir.
Okay, then we are adjourned. Thank you, everyone.
All right, and the last one we're going to do is Robert Tellis, he was an ex-politician in Las Vegas. Oh my God, I'm tired today.
District Court, Clark County, Nevada, State of Nevada, Plaintiff versus Robert Tellis, Defendant, case number. We, the jury in the above entitled case, find the defendant, Robert Tellis, as follows. Murder with use of a deadly weapon, victim 60 years of age or older. Guilty of first-degree murder with use of a deadly weapon, victim 60 years of age or older. Special verdict. The jury unanimously finds the murder willful, deliberate, and premeditated. The jury unanimously finds the murder was committed by means of lying in wait. The jury unanimously finds the murder was committed by means of elder abuse. Guilty of first-degree murder with use of a deadly weapon, special verdict. The jury unanimously finds the murder willful, deliberate, premeditated. Your verdicts as read?
Yes.
Juror number 2, are these your verdicts as read?